Morning, everybody. I hope you can hear me properly. If not, please shout. As Eva has just said, it was back in July 2018 that I addressed a similar gathering at the conference hosted by the University of Rotterdam, which, if I remember, was entitled Innovating International Business Courts, a European Outlook. And my talk was under the heading, A View from the Business and Property Courts in London. And I recall very well the stormy reaction that I managed unwittingly to generate. I'm therefore very grateful to have the opportunity 3 years later, after so much unexpected water has flowed under the bridge, to have an opportunity to revisit the subject at this timely conference on international commercial courts in Europe and Asia. As Eva has said, I'm no longer in charge of the business and property courts of England and Wales. That role is now ably undertaken by my colleague, Sir Julian Flo. Instead, as you've heard, I'm the Master of the Rolls and Head of Civil Justice in England and Wales. And as such, I work closely with my successor, Sir Julian, who is Chancellor of the High Court now. And I keep closely in touch with developments in commercial courts across Europe and Asia, insofar as all that has been possible over the last 18 months since the really appalling COVID pandemic struck in March 2020. I looked back at what I said in July 2018, I should say, and tried to reconstruct what had caused such a lively debate. I spoke about the common law in the context of Brexit. And then I said something about the creation and the intent of the business and property courts here in England and Wales, before talking about the establishment of the new business dispute resolution courts in Europe. And at that stage, if I recall, we were looking at new international commercial courts in Paris, Frankfurt, the Netherlands, and Brussels, amongst others, perhaps. I did not think that what I said was actually all that controversial. I said that legal systems are not and should not be in competition. And that I had, and by the way, I still have, huge respect for my European judicial colleagues and have worked closely with them for many years. I would also, had we then been talking about Asian commercial courts, which we weren't, have included my respect for the judges of those courts too. I suggested, and I still believe today, that it is extremely important for judges in different jurisdictions to collaborate and cooperate with each other and exchange ideas and information about their justice systems. No justice system is superior. We are all trying to offer an excellent service to our domestic and international court users, whether they are businesses or individuals. And collaboration between our judges will assist in this process. Well, I said that back in July 2018. And I also said, and still believe today, that the three most important ingredients for a successful business court in Europe and the rest of the world are first, and perhaps foremost, the quality and integrity of the judges in the court and the lawyers who practice within it. Secondly, to introduce appropriate IT to make sure that the court's processes are digital from end to end. And thirdly, to make sure that appeals are limited to those that are given permission, mostly on points of law, and that as a result, delays in the initial dispute resolution process and in any appeals that are permitted are limited. One of the things that has blighted commercial dispute resolution in many countries over many years is a system that allows unlimited rights of appeal on essentially factual issues all the way to the highest court in the particular jurisdiction. Essentially, speed is of the essence. I want to revisit this morning my second point, namely, making sure that the court's processes are digital from end to end. COVID-19 has forced all of our jurisdictions to move from face-to-face hearings to remote or Zoom hearings. Here in the UK, we did so quickly and managed to continue to dispatch civil and commercial business without significant interruption. But what I was talking about in 2018 was not the use of ordinary technology within the justice system, but a new approach to delivering justice for the benefit of court users. New commercial courts and old need, I think, to find methods of decision-making that are more streamlined, less costly, and far less time-consuming. The Hmcts Reform program in England and Wales will ultimately mean that any civil or commercial case can be started and progressed online with integrated mediated interventions aimed at resolving the dispute applied within the online framework. I'll come back to what more needs to be done in a moment. The debate that followed my speech in 2018, I recall, raised some interesting questions, some of which Eva has already mentioned, and Sandra too, as to which of the commercial courts were in fact the oldest and the most experienced, and whether newly founded international commercial courts could or should utilize the common law, whether they could or should utilize English rather than the lingua franca of their seat, and could or should abrogate the locally applicable civil procedural code. Now, all of these questions, perhaps particularly the last, remain alive today. Since then, however, in 2020, a joint project between the European Law Institute and UNIDWAT has resulted in the adoption of their modern European rules of civil procedure, for which I may say I have a very high regard. The project demonstrated how much is shared between common law and civilian systems of civil justice when so many commentators seek to emphasize and exacerbate perhaps the differences. These rules, the rules of civil procedure, modern European rules of civil procedure, hugely repay study. Even though they run to 536 pages, I think the guts of them is in less than 50 pages. I'm going to come back to them in a minute. But since 2018, there's also been much international collaboration between commercial courts. The judges of England and Wales, led by Lord Thomas in particular, gave birth to the Standing International Forum of Commercial Courts, or SIFOC. And that forum has really been hugely successful. And I'm pleased to say that many of the new commercial courts are represented at its plenary meetings and on its working groups. And I believe it provides an invaluable forum for cooperation and mutual understanding. There has been bilateral collaboration also between our courts. The Cour commerciale de Paris and our business and property courts have exchanged visits and online seminars. And whilst COVID has meant that many meetings have had to be held remotely, very valuable interactions continue. And many other bilateral and multilateral discussions have taken place really across Europe. Courts in Stuttgart, the Stuttgart Commercial Court, in Mannheim, the Mannheim Commercial Court, Frankfurt, now in operation, as is the Netherlands Commercial Court and many in the Middle and Far East. And it's perhaps worth noting at this stage what they are doing. Municipal justice systems exist primarily and obviously to serve the citizens of their own state, whilst international commercial courts with rules that are separate from the courts of the country in which they are based are in a different position. They exist to serve their national and international business community and can sometimes provide a very different kind of dispute resolution. But the ability to break away from a domestic civil procedure code is not always straightforward. And that was what our discussion back in 2018 demonstrated. Interestingly, the business and property courts of England and Wales, and those of the Southern District of New York, for example, are domestic courts whose rules and practices have attracted non-domestic commercial litigants from international places. But those courts remain municipal courts tied to the civil procedure of their national home. Now, in contrast, the international commercial courts in many other countries in Asia, the Middle East, and some in Europe use purpose-built procedural rules and often English as their working language. And this allows for more flexibility, but can raise issues of status and enforcement of orders and judgments. Now, the procedural rules that courts use have been tackled in part by the Ely Unidroit rules that I mentioned earlier. But I would caution one thing about them, that what we need is a procedural process for a technological age, not an age of paper and not bureaucratic procedural rules. But as the Ely Unidroit rules have shown, it is possible to create some high-level principles to govern litigation that are not hidebound in municipal systems that are centuries old. Those principles include extremely sensible rules on each party's duty to cooperate with the court, with the process, and with each other. They include a duty to attempt to achieve compromise and settlement, and duties on the court to manage cases effectively, to treat parties equally, and to deal with all cases proportionately. Even more forward-looking are Rules 9, 10, and 50, which seek to integrate alternative dispute resolution into the rules themselves and into the dispute resolution process itself. In many jurisdictions, ADR is kept entirely separate from the court processes, but it should not be like that, even though it often is. And sometimes that is the case because there's insufficient trust in the providers of alternative dispute resolution to allow them to enter the mainstream court system. The Ely Unidroit rules also include, as I've said, a really important duty to seek settlement. This is something that is often honored only in the breach. So the next step will be to ask how real effect can be given to that duty. In England and Wales, the government has just introduced legislation to create an online procedure rules committee to regulate the online litigation process. Now, this will allow for a higher level procedural governance, recognizing that it's not possible to prescribe every specific step taken in the online space. That will be particularly so as artificial intelligence is increasingly used to streamline the case preparation stages. I expect that it will be possible in a relatively short period for every civil, family, and tribunal case started in England and Wales to be initiated online and progressed, at least in its procedural stages, through an online process. But in some ways, everything has changed since 2018. COVID has added a new urgency to online dispute resolution. It's created a world full of remote hearings from which many lawyers are actually reluctant to retreat because of the convenience for them of not having to travel to courts in different places. To be blunt, remote hearings can boost their earnings potential. COVID may ultimately lead to the introduction of procedural rules that are less cumbersome and less steeped in municipal procedural codes. And as I've said, the new commercial courts anyway have the opportunity to employ state-of-the-art technology and appropriate rules to provide a process that more appropriately meets the needs of businesses in the 21st century, without, of course, affecting the quality of justice. I've said nothing so far about crypto assets, smart contracts, and on-chain transactions and dispute resolution. The UK Jurisdiction Task Force, which I chair, has introduced digital dispute resolution rules, which aim to provide a kind of streamlined arbitral or expert determination procedure to resolve disputes arising on-chain and in the digital space. Now, this again is something that the new courts might wish to emulate, since the commercial disputes that will need to be resolved in the coming years will be quite different from those that we're used to. These digital dispute resolution rules are revolutionary in some ways because they allow for very speedy determination of digital disputes. They allow for the appointed arbitrator or expert to implement decisions directly on-chain using a private key, and they allow for the optional anonymity of the parties. In an era of smart contracts and digital commercial documentation being used in financial services, banking, transportation, amongst other sectors, where the facts will be recorded immutably on the blockchain, parties will not, I think, accept endless and costly analog dispute resolution processes. So what do all these developments of which I've spoken mean for the world's new commercial courts, and for the old ones as well? I think there are some key features on which we should all be able to agree, and hopefully we will all be able to collaborate to work towards achieving them. First, we all need to focus on the changing nature of the disputes that business people require to be resolved. It's no use building court systems to resolve the disputes of yesteryear arising from piles of analog documentation when disputes now arise online from entirely digital communications and often on-chain transactions. Secondly, as I've been saying, the focus on domestic procedural codes will only serve to hold back the success of modern commercial courts. In the new digital environment, all procedural codes need a thorough overhaul. That's happening in England and Wales in the online space, as I've said, and the new commercial courts have an even better opportunity to rewrite the rule book, perhaps drawing on the excellent work of Eli and Untitled. Thirdly, our commercial courts need to embrace technological advances, not just remote hearings and electronic disclosure processes, but the blockchain, smart contracts, the use of artificial intelligence to cut legal costs and streamline dispute resolution. I predict that, as always, the most efficient will succeed and the most cumbersome and procedurally complex will not. There is a point also that can be made about artificial intelligence. Lawyers tend to be very cautious about its use in the legal context. One often hears lawyers and judges saying that artificial intelligence is dangerous, prone to bias, and should not be used to facilitate court proceedings or legal advice. The truth, of course, is that artificial intelligence is already used in almost every aspect of business and domestic life, including the law. Every Google search you make is facilitated by it. Legal research is assisted and made quicker and more efficient by artificial intelligence. online dispute resolution systems inevitably use artificial intelligence to ensure that the cases are progressed effectively and to suggest compromises and resolutions where appropriate. In ordinary domestic life, artificial intelligence assists your online shopping and the location and selection of goods and services across the entirety of consumer demand, and the production of data about subjects as diverse as COVID and banking. It's true, of course, that artificial intelligence can, if not properly used, introduce and perpetuate bias and inequalities. It can provide solutions that are unreliable, as has been pointed out frequently when it's used, for example, in relation to criminal sentencing or predicting litigation outcomes. But these problems do not lead to the conclusion that we should pretend that artificial intelligence is not here to stay. It very much is. It means instead that we must understand it better and learn to set out the value and uses of human interventions, perhaps to sense check outcomes that are derived from AI programs. I will leave the question of robot judges for another day, but just treading gently, as I always say, some 60 million disputes are resolved every year on eBay without human intervention. And when it comes to the kind of commercial disputes we're discussing today, I think robot judges are probably a long way off. And that's not because they could not, in some types of case, provide perfectly reasonable outcomes, but it's because dispute resolution is about justice, and no justice system is sustainable unless those it serves have confidence in its practices, processes, and outcomes. And I can't see that commercial organizations are likely in the near term to repose confidence in a justice system driven entirely by AI. That's perhaps even more the case in relation, say, to a family dispute, as, for example, raising the question of, for example, which of a father or mother should have custody of a child. The extent to which human emotion feeds into a justice system, even a commercial justice system, is an interesting one. But perhaps it's, again, one for another day. Now, forgive me, I was diverted from drawing the threads together as to what the new technologies mean for the world's old and new commercial courts. A fourth important factor is to ensure that commercial courts provide court services that complement and support commercial arbitration. I see you have a session on that this afternoon. The Business and Property Courts in London and the Arbitration Act in the UK are friendly to the commercial parties that decide to arbitrate in London. The Commercial Court in particular has supervisory jurisdiction over London arbitration under the Arbitration Act. The links with the arbitration community are strong and beneficial. This is something that is not always replicated in other jurisdictions, but I think that strong court support for an arbitral seat is hugely beneficial to the international parties using it. So let me come to my conclusions. I hugely welcome the new commercial courts in Europe and in Asia. I hope they will play a full part in CIFOC, as I've said. There is more than enough room for a wide diversity of dispute resolution processes available to the international business community. In the commercial world, parties to commercial contracts can and do choose their applicable law and forum and their preferred mode of dispute resolution. They will and should continue to do so. As I've said, the most successful commercial courts will have judges of the highest quality and integrity. They will have digital processes from end to end and limited rights of appeal. The key is to ensure that users have absolute confidence in the integrity of the system. But there is no competition Different parties, whether individuals, businesses, or even states, require different kinds of dispute resolution services. As in all things, diversity is everything. Thank you.
Thank you very much for that very interesting speech. I have not yet seen any questions from the audience. I invite you to type them in the Q&A section on the bottom of your screen. In the meantime, I would benefit from the time I have to ask 2 questions. You mentioned ADR and mediation as a prerequisite for litigation. I find that a very interesting topic, and I wondered, from your experience, has the situation with COVID-19 changed anything to the attitude of parties and lawyers to mediation? We had a quite interesting project as well at BICL, where we call for breathing space in the pandemic, giving the parties the opportunity to renegotiate rather than litigate, and use ADR to keep the disputes away from the courts and avoid backlog. So have you seen that in court practice or in practice generally, that there is a shift to mediation and ADR also because of the situation in which we live?
I think there was initially, when COVID struck and when courts were immediately closed across the piece, really, some parties used it as an opportunity either to go to mediation online or to settle their disputes. I'm afraid that didn't last long. I think they all bounced back into normal litigation mode quite quickly after that. The point I was making in my speech about ADR is that it really needs to be integrated into the process. And I've said this quite often and been slightly ridiculed for it. I've said that alternative dispute resolution is a misnomer, because it should really be dispute resolution. The whole process of dispute resolution should include different ways of finding solutions to the problem between the parties, to the issue that separates them. And in my view, online dispute resolution provides an absolutely classic opportunity for integrated ADR. At its most basic, if there is a dispute about £1 million and the defense is that only £500,000 or dollars or euros is owed, a bot could easily suggest that the claimant took £500,000. And so I think there are many ways, as we say, to skin a cat. And I would very much like to see the whole dispute resolution process become integrated with mediation, all as part of the process, being offered as time goes by, not just once, but repeatedly. Because something else about this is that every case, and this is my experience born of many years in commercial litigation, every case has a time, has a sweet spot when settlement is possible. But it's not the same time for every case. So you can't just have a judge bowling in on day one and saying, why don't you settle? Because it won't work. But you may well, on day 20 or day 200, have that sweet spot. So you need to have a process which watches out for and continually proposes mediated interventions and other ways of resolution.
Yeah, that's very interesting, and I think that that should be the direction in which we all should be going. I have another quick question about the online aspects that you mentioned, which I find personally also very interesting, the whole topic of AI and all the questions that are raised. I mean, we don't have time to discuss that here. I just have a very simple question. If we move to online hearings on a more regular basis, what about the public character of hearings? Is that going to fundamentally change?
Fascinating and difficult. It is absolutely critical that hearings are open to public scrutiny and public attendance. And what we have done in terms of Zoom hearings in the UK is give access effectively to the press and members of the public who wish to attend online hearings. And initially, this was thought to be likely to be really problematic. We were concerned about disruption. We were concerned about maybe people who had particular views wanting to participate when they shouldn't. What we found was the reverse, that the press absolutely love remote hearings because they participate. They can sign on and have it on in the background while they're doing something else. And they can perhaps even have 3 hearings, listen in to 3 hearings at the same time. And the public too are able to join, provided there are controls to prevent any disruption, which is easy enough technically. So you can give private access. I think the bigger question, actually, Eva, which I think is even more interesting, is when you have an online dispute resolution process, which is proceeding in cases that do not come to court, how do you ensure transparency and public accountability in relation to that online process? So I envisage in the UK, in England and Wales, a system of civil justice where 2 million, 3 million claims a year will be started and progressed online. Now, at the moment, a member of the public can go to the court and see the originating process. I mean, they don't very often because it's a very cumbersome analog process, but if there's something of high profile, sometimes they do. They can't see the whole court file, but they can see the originating process. And how do you do that online? And of course, it's a challenge because it's different. And I think the answer is almost certainly scrutiny, rather than trying to replicate exactly the same historical transparency that we had in the past. Almost certainly, any form of public scrutiny would be better and more effective than what we have at the moment, where you have to go along to a dusty room with lots of papers and find a document that is probably very difficult to find and extremely time-consuming to find. Doing it online is much easier. So I think it can be done. Like everything in the new technological age, it has to be thought carefully through, and you have to be guided by the principles of openness, of transparency, of justice that guide everything we do within the justice systems.